Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today we're going to try to make sense of the law of bankruptcy. Now, everything that I'm going to tell you today is every chapter in this little story is probably worth a separate video. But I wanted to do an overview video, and if you need more information about a particular chapter or you want to find out more nuances about how things work, address some questions to me by email and I will do my best to try and make a video to explain it. But this video comes by virtue of a request to explain the bankruptcy process and system and what it's about and what it's for. So that's what I'm trying to do here. So you may not be aware of it, but bankruptcy is actually in the Constitution. Article 1, Section 8 of the Constitution provides for it. Article 1, Section 8 of the Constitution provides that Congress shall establish uniform laws on the subject of bankruptcies throughout the United States. While state law may have interplay with bankruptcy, for example, in terms of how a lawsuit might be decided in bankruptcy court, the rules of decision and the rules governing how bankruptcies are administered are all entirely federal. And it's important to understand the history. Bankruptcy came about because of the experiences that many of our founding fathers had in England and all over Western Europe, truthfully. In the 16th and 17th century in Europe and England, there were these things called debtors' prisons. If you owed a debt and you couldn't pay that debt, you just didn't have the money, you didn't have the land you could sell off, there was no way for you to make the payment that you were required to make because your business failed or your business burned down or something like that, then they would put you into a debtor's prison. And a debtor's prison was essentially just that, a place where you were in a workhouse where you had to basically work to pay off your debt. And those had such terrible consequences for the people who went in there. A lot of people would go in healthy and come out with tuberculosis and other communicable diseases because the living conditions in those places were definitely not up to Eighth Amendment standards in the United States. But in order to get rid of these debtors' prisons, the United States came up with this idea of bankruptcy and wrote it into the Constitution. So, in addition to that, in 1833, the federal government outlawed any form of punishment for debt. If you have a debt, the way you deal with it is through the bankruptcy system. You can't put people in jail because they owe a debt. Let's look at a case that tells us a little bit about how the purposes of bankruptcy fit into the bankruptcy code. This is the case of Grogan versus Garner. It's a Supreme Court case that arose in the Eighth Circuit. The issue here was whether or not a fraud judgment could be discharged in bankruptcy. And in the process of describing the issues in bankruptcy, here's what the court said about the purposes of the bankruptcy statute. This court has certainly acknowledged that a central purpose of the code is to provide a procedure by which certain insolvent debtors can reorder their affairs, make peace with their creditors, and enjoy a new opportunity in life, and a clear field for future effort, unhampered by the pressure and discouragement of pre-existing debt. But in the same breath we have invoked this fresh start policy, we've been careful to explain that the Act limits the opportunity for a completely unencumbered new beginning to the honest but unfortunate debtor. The statutory provisions governing non-dischargeability reflect a congressional decision to exclude from the general policy of discharge certain categories of debts, such as child support, alimony, and certain unpaid educational loans and taxes, as well as liabilities for fraud. So there are three flavors of bankruptcy that I want to talk about today. That's Chapter 7, which is liquidation bankruptcy, Chapter 11, which is sort of the corporate bankruptcy, and Chapter 13. Before we actually go into those particular issues of the three different chapters, I want to give you a basic overview of the process, and then we'll look at some of the individual chapters. Here is the process for bankruptcy. As I mentioned earlier, it's uniform laws on the subject of bankruptcies are established by Congress. The procedural aspects of bankruptcy are governed by the federal rules of bankruptcy procedure. There is a bankruptcy court for every judicial district in the country. Each state has one or more judicial districts. For example, in Missouri, we have the Eastern District and the Western District of Missouri. Both have bankruptcy courts. There are 90 bankruptcy districts across the country. The bankruptcy courts generally have their own clerk's office. The court with official decision-making power over federal bankruptcy cases is the United States bankruptcy judge. We'll talk more about that in a minute. And even though there is a bankruptcy judge, in most cases, if you file a bankruptcy case, you'll have very limited interaction with him. And as I mentioned in the case, the courts do say often that it gives the bankruptcy discharge only to the honest but unfortunate debtor, a new opportunity in life, that sort of thing. So there are 4 real key players in a bankruptcy. The first is the judge of the district court. Now, the federal district court judge is a judge who is appointed by the president and confirmed by the Senate. And his job is to oversee at a very high level the workings of the bankruptcy court in his district. The next player in this is the bankruptcy judge himself. The bankruptcy judge is not a real federal judge, meaning he is not appointed under Article 3. And because he isn't appointed under Article 3, because his judicial robe comes to him through Article 1, he does not have the judicial power of the United States himself. His judicial power is derived from the district court judge who sits above him. Then another party that you'll get to know, particularly in chapters 7 and 13, is the U.S. trustee. The U.S. trustee is a position appointed by the Department of Justice, and in that position as a trustee, they oversee the bankruptcy process, whether it's for individual debtors or for corporate debtors. And as a result of that, they get to represent the government in any kind of bankruptcy litigation that involves the government. And you'd be amazed at how much bankruptcy litigation does involve the government. You probably saw the video that I did recently about the Purdue Pharma bankruptcy. The federal government is sort of sticking its nose in there. And thank goodness they are, because you don't want bad law continuing in the United States. And that was what was going to happen if that plan was approved as it was. The fourth key player in this is the creditors. And there are essentially 3 types of creditors in a bankruptcy. The first kind of creditor is a priority creditor. And the priority creditors are the bankruptcy court, the bankruptcy trustee, the bankruptcy clerk. If you get hit with any sanction or penalty, you're going to have to pay those first. Then anything like a student loan or a child support obligation, those kinds of things are priority debts that must be paid in full. The next level of debt is the secured debt. Now, a secured debt is a debt where the debtor owns a piece of property. The most common example would be a car. A lender has a lien on the vehicle, which means that at any point in time when the lien holder believes that the credit is not good or they're unlikely to be repaid, they can go and seize that vehicle. They can repossess it. And that is a particularly ugly experience for someone to have the car that was in their driveway when they went to bed last night to wake up in the morning and find out that their car is now gone. And that unfortunately does happen to a lot of people because they don't pay their debts. But the repossession of a vehicle with a lien can't occur once the bankruptcy has been filed. There is something called an automatic stay. The notice goes out to any place where there is an action pending against the debtor, and for two reasons. One, because in most cases the debtor knows when they've been sued and will let the court know, and the court will send the notice there to the clerk of that court to let them know that the case is stayed automatically. The trial court can't do anything about it, and neither can the creditor who wants to get paid. There is an automatic stay, and that's just the way it is. There can be a situation where the creditor can recover that vehicle through an action in replevin, but only in the bankruptcy court. So the creditor will have to come into the court and file an action to recover the property. And that often happens, and it's often objected to by the debtor, and a lot of times that stuff is worked out. There's priority and secured, and then there's unsecured credit. Unsecured credit is that situation of your MasterCard, your Visa, your Discover card, your American Express, your Diners Club. All these credit cards are, for the most part, unsecured. And by unsecured, I mean there's no collateral that American Express can go to and seize that collateral and take it and sell it to repay your debt. And so because they are unsecured creditors, they have the lowest priority to get paid in the bankruptcy. So with that, let's talk a little bit about Chapter 7, and let's go to the U.S. Court site and take a look at that now. So one chapter of bankruptcy is called Chapter 7, and it is the liquidation bankruptcy. And initially, at least up through about the 1990s, Chapter 7 was something that many people wound up taking. It was often less expensive than other forms of bankruptcy. Now, however, the availability of a Chapter 7 discharge and liquidation bankruptcy is greatly reduced because there is a means test. Basically, you have to be pretty poor to get a Chapter 7 discharge because you have to have a net worth of, I think it's less than $10,000, and essentially it's designed to prevent people from abusing the system. If a debtor's income is less than 150% of the poverty level, as defined in the bankruptcy code, the debtor is unable to pay the Chapter 7 fees, even in installments. The court can waive the requirement that fees be paid. But take my word for it, it is very difficult to get a court to waive any fee in these cases. And the process in bankruptcy and Chapter 7 is fairly, well, let's just say it essentially cleans out a debtor other than exempt property. Now, every state has different exemptions. In other words, the amount of property that you can exempt out or opt out of bankruptcy in different states varies. In Florida, for example, you can exempt real property if you've owned it for more than 1,215 days. And it's less than 160 acres out in the rural areas, or a half acre or less in town, in a municipality. But in Missouri, for example, they have a whole list of exemptions. You can only exempt $15,000 of value in your home. You can only exempt a car up to $6,000 if you're filing jointly with your spouse, and only up to $3,000 if you are filing separately or alone. Jewelry, you can keep $1,500 worth of your jewelry and $1,500 worth of your firearms in Missouri. But the process is essentially the same irrespective of what bankruptcy district you're in. The trustee, who is basically an employee of the Department of Justice, with the exception of Alabama and I think one other state, those people, the trustees, will essentially gather up all of your property. Everything that you own that is not exempt, that doesn't fall into one of the exemptions, everything that can be sold will be gathered up and it will be sold. So for example, if you have a car that you bought 2 years ago and it's worth $15,000, well, you're not going to be able to exempt that under the bankruptcy exemptions. So as a result, what happens? they will wind up selling that car. At any rate, after everything is gathered up, it is auctioned off or sold off, and that is used to pay off the creditors, and the debtor is given a discharge from bankruptcy, meaning they don't owe a blinking penny for anything. So that's all about Chapter 7. Now let's talk real briefly about Chapter 11, because although it is designed primarily for businesses to reorganize their debt, there is nothing that prohibits an individual from using Chapter 11 as well. But it is usually unwise to do so because you undertake a lot of administrative burdens. But basically what happens is you go into the court and you say, my debts exceed my ability to pay them. You file the appropriate forms and you ask to remain the debtor in possession. Now what that means is that everybody else is hit with an automatic stay. All your creditors can't come after you and collect on you. And you get to work out a plan with those creditors and with all of your, there will be a committee of secured creditors and a committee of unsecured creditors who will get together and they will try and figure out how much you can pay and whether the payment plans that you are suggesting are reasonable and rational, and usually the plans are confirmed. It depends a lot on the size of the individual corporation. To give you an idea, Purdue Pharma filed under Chapter 11, Mallinckrodt Pharmaceuticals filed under Chapter 11, General Motors filed under Chapter 11, wiped out all the stockholders who owned General Motors stock. Same thing with Mallinckrodt, wiped out all the people who owned Mallinckrodt stock. And that is essentially what happens in the bankruptcy. The people who are investors in the corporation take it on the chin. Now, because these corporations have lots of employees and usually ongoing expenses, the debtor will remain in possession of the company. In other words, he will not be replaced by a trustee to manage the bankruptcy unless he does something that causes people to believe he isn't playing square. And in fact, the debtor in possession, the people who run the company in Chapter 11, become fiduciaries, and their job is to look out for the interest of all the creditors. So if they were previously interested in making a profit for the company, now what they're supposed to be interested in is taking good care of the creditors to make sure that they get paid. The extent to which that actually works out, my experience with the bankruptcy and Mallinckrodt is that they actually care a lot more about just getting out of bankruptcy and getting a discharge so that they can continue to make a profit. But be that as it may, this is how it's supposed to work. I would also point out that usually in a Chapter 11, there's a lender involved who comes in and does bridge financing to get them up and running to solve any cash flow problem. So the debtor remains in possession, continues to run the business, basically negotiates with all of their creditors, and reaches a situation where people are going to get paid a certain amount based on what their claims are. For example, in the Mallinckrodt bankruptcy, there were a number of creditors who had claims against Mallinckrodt that were litigation claims that were not opioid claims. They separated the opioid claims and put them in a different bucket, so to speak. And all the rest of the unsecured creditors went into a separate bucket, and they authorized $150 million for that bucket. And when we figured it out, we were probably going to get 7 cents on the dollar if we stayed in and opted to receive anything. And that was only if they didn't spend every last dime of that $150 million defending the claims that would be brought against that $150 million. Because when they set this up, and this was very clever, I have to give them credit for it, they decided that the claims litigation process, where basically the claims are decided whether or not they're a valid claim or not, those can be defended, and the money to pay the lawyers to defend those claims comes out of the $150 million. So it's what we call a reducing kind of insurance, so to speak. At any rate, our creditors got absolutely nothing out of that bankruptcy except sore fingers from having to type a lot of stuff in that case. So Chapter 11 is something that is a very specialized area of law. It is not something to be attempted pro se. There are certain successful pro se plaintiffs in these other chapters, but almost never a pro se plaintiff in a Chapter 11. I'm not even sure a bankruptcy judge would entertain one. Now let's take a look at Chapter 13 and the process and some of the issues with that particular program, which is often called the wage earner plan. The other common way to file bankruptcy for an individual is a Chapter 13. A Chapter 13 is often called the wage earner plan, and it's designed for people who have a job and a steady source of income and who can pay the trustee the amount of money that they wind up agreeing to. Usually, plan payments are limited to either 3 years or 5 years. In no case may a plan go longer than 5 years. And during this time, creditors cannot start or continue collection efforts. Who is eligible for a Chapter 13 plan? Anybody with less than $2.75 million in combined secured and unsecured debts. An individual cannot file under Chapter 13 or any other chapter, however, if in the prior 180 days you've had a petition dismissed for willful failure to appear before the court or for other reasons, or it was voluntarily dismissed after creditors sought relief from the bankruptcy court to recover property on which they held liens. So there are certain situations where you can be ineligible for relief under the chapter. But basically how it works is this, that you provide the court with a schedule of assets and liability, a schedule of current income and expenditures, and all of the contracts and leases, for example, your cell phone lease, your contract for the lease of your apartment, that kind of thing, and a statement of financial affairs. Courts charge a $235 case filing fee, a $75 miscellaneous fee, and if this winds up being converted into a Chapter 7, they'll charge you a Chapter 7 fee of $25 later on. But essentially, you get this list of creditors, the amount and nature of all their claims, the source, amount, and frequency of your income, a list of your property, and a detailed list of your monthly living expenses, and you have to have this down pretty much to the penny. Food, shelter, clothing, utilities, taxes, transportation, medicine, all that stuff. And then you submit that to the court, and you do that usually with a projected payment plan. You'll go to the court and you'll say, this is how much I think I can afford to pay. Now, after that, you wind up having a meeting of the creditors. And the creditors get together and they get a chance to ask you questions. The trustee gets a chance to ask you questions. And then, after that, if there are issues to be decided, there may be individual hearings with individual creditors. But at some point, you get to the point where there is a confirmation hearing on your plan. And if the plan is confirmed, you are entitled to relief from creditors over the course of the 5 years or 3 years where you make these payments. And then at the end of those 3 or 5 years, you have a discharge from bankruptcy. So let's say that you owed maybe $1,500 on a problem you had with a particular cell phone provider. And they want that money and they were prepared to sue you to get the money. Well, if you go into bankruptcy, they can't sue you because of the automatic stay. And then they will take whatever amount of money the trustee is going to give them over the course of the next 5 years to repay that debt. Some smaller unsecured creditors are going to be paid in full. There are going to be a lot of unsecured creditors who take half, 50 cents on the dollar. And some may get less than that because the bankruptcy system evaluates priority, secured and unsecured claims, as we mentioned earlier. So here are the key takeaways about bankruptcy. First, bankruptcy is there to help the honest but unfortunate debtor, the person who got in over their head, the person who never intended to run up a bunch of credit card debt. However, if you're in the alternate category where you did intend to run it up and it's basically a large fraud scheme, the court does not have to grant you a discharge in bankruptcy. 2. Bankruptcy prioritizes giving relief to the honest debtor because it's about a fresh start. It's about giving somebody relief from the oppressive forces of debt. And as I mentioned, you can be denied relief if you engage in fraud or intentionally hurt people. So, for example, if you commit an act that is an intentional tort, for example, assault or battery, and you hurt someone badly, you can be held accountable in bankruptcy court by not getting a discharge for your debt. And then finally, creditors always take less in bankruptcy than they would get if they collected fully on their debts, but that is the way the system is arranged. It places the blame, really, on the creditors for extending credit when people are overextended. Well, folks, that's what I have for you today. Hopefully this has been educational, helpful. Maybe you've learned a little something about bankruptcy. Again, if you have any specific questions, please send me an email, aldewit7@gmail.com. It's that time of year when it's hotter than Satan's big toe outside. At least it is down where I'm at. And many people who have pets keep them outside. On days when it gets this hot and this brutal outside, it's a good idea to remember that they need water and they need attention. They need shade. They need to be able to protect themselves from the heat. Pets are supposed to be your best friends. We need to treat them that way. Thanks for watching. Catch me down here at the beach next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.